I think it's absolutely necessary. Sealing now is available for convictions. Do you know how many times you've ever been pulled over and they see a DWI conviction, or how many times you applied for a job and they see DWI conviction? There's still a lot of taboo and negative taboo that won't let you get jobs or get you extra searches on DWI convictions. If you qualify for a DWI, if you can seal a DWI conviction, it's absolutely mandatory. You have to do it. Sealing your record is not going through the entire legal process. In fact, just to seal your record, you'll come to my office, we'll sign a contract, you'll sign part of the petition, I'll prepare the petition, go to court, argue it, get all the parties ready to go, and then all you have to do is come to court for maybe 15 minutes. We discuss with the judge either signs it or doesn't based on your qualifications, and it's over. It's harmless, painless, and maybe costs you 15 minutes to an hour of your time, and it's absolutely necessary. I would say from the moment you walk in the office, we can get the contract and rolling that day, file the petition the next day, be there within the court within about 30 days. You should be able to seal your record probably usually in about 30 days. Depending on different aspects of the new legislation under House Bill 3016, you may have to wait up to 5 years, but it's anywhere between 2 and 3 years depending on if you had an interlock usually. But if you got convicted back in the 90s, chances are anything more than 5 years, you're automatically available to get it sealed if you qualify under House Bill 3016. If you have any of the documents, bring them. If you have a judgment, a sentence, any plea paperwork, bring it. But usually we can get all the documents that we need from the county clerks, from True Public Data, downloading it online. We can usually get all the documents we need. You really don't need anything. We can handle it all. Really, it doesn't matter how your DWI case was handled, it just matters on what you actually pled to. Did you plead to a DWI with under a 0.15 breath or blood test? Then we'll have to look at if it's on the face of the judgment that it was below, no problems. If it was above, we're gonna have to look at, did you plead down? Did the judge know about these things, into the offense report? But really you only go back into the facts and whether an attorney properly handled your case if we were gonna do some sort of writ or post-conviction remedy to try and reopen the case. But a sealing of a conviction has nothing to do with that. A sealing of a conviction really is just, what did you plead at, and does it qualify under House Bill 3016? Yeah, so a lot of people say you got arrested and convicted 10 years ago, and you just got arrested, 2 years ago. Well, now you can't do it anymore. So the faster, the sooner, basically the moment that you can actually seal your record, you should do it. Because if you ever get arrested after this conviction of DWI, you're gonna get kicked out and you can't seal your record. So where you may have been eligible 10 years ago because of an arrest that just happened this year, you may not be eligible to seal your record anymore. So the moment that it comes available, get it done. This is crucial distinction between expunctions and sealing. An expunction literally erases everything. You can deny ever being arrested. It wasn't until this year that you can actually seal a conviction. So what the sealing of this conviction is going to do is private citizens won't be able to see it. Certain housing, basically the only people who will be able to see it, law enforcement, government, boards, like medical boards, dental boards, those kind of things will be able to see it, but it will say sealed. So you can't actually deny ever being arrested. However, show me call me, talk to me about the language in the contract or whatever you're reading. It says, have you ever been charged? Have you ever been convicted? All these things differ, but you can't ever deny you've ever been arrested. Typically, in most jurisdictions, this is all brand new, it will require a hearing in front of a judge. Most petitions for non-disclosure do require a hearing in front of a judge, but this really is a case-by-case basis. Some judges may say, look, he qualifies, it's under there, he's never been arrested before, I'm going to grant it. Some judges may want you to come in. A hearing should never take more than 15 minutes with a judge. No, once a case is actually sealed and the judge grants it, it's done. The order is signed, it goes into effect that date. I'm trying to think if maybe you got arrested like the afternoon after you left court, could they reopen it? But no, the judge already signed the order. It's already granted. The vehicle is in it's already sealed. So no, once the judge signs it, the order, it's done, it's sealed. I think it's going to be different with every attorney on how much they're going to charge, but I'll tell you that the only firm cost is going to be the filing fee associated with it, which is usually around $300 to $500. Then you'll have really just the attorney's time, what court it's in, how much travel's involved, that kind of stuff will add on to the filing fee. Yes, absolutely. Your prior record will come into play because this isn't guaranteed. It is, at the end of the day, up to the judge. And so if a judge sees that you've had a prior felony or prior conviction, he can refuse to actually seal this latest DWI. And certainly if you get arrested after a DWI conviction or you get convicted after this DWI conviction, that can prevent it from getting sealed as well. Once it's sealed, it's done. It is sealed forever. There's no way they can reopen that. After it's been sealed, the only people who can really see your DWI record are police, school boards, medical boards, dental boards, and like the federal government, like the Army, INS, immigration, that kind of stuff. But every time they see it, they'll see DWI conviction, sealed, petition for non-disclosure.